Namibians will head to the polls in less than 3 months to elect head of state as well as members of the National Assembly. Prior to Wednesday, the 27th of November, 2024, the constitutional body mandated to manage and conduct elections, that is the Electoral Commission of Namibia, has a number of items to tick off on its to-do list. This past week, it managed to tick off a major item following the recently concluded general registration of voters. That is the announcement and release of the provisional voters register. This register, released Thursday afternoon, is currently open for public scrutiny and the filing of objections, if any. This evening, our pursuit is to crystallize the legal avenues available to those who deem themselves aggrieved, be it before polling day, on D-Day, or thereafter. Believe us when we say it is our official recommendation that you fasten your seatbelts for what promises to be an enthralling episode of the Wheels of Justice. Greetings, Namibia. My name is Daniel Nadunya. We'll be back in a moment. And the wheels are officially in motion. Joining us for this evening's proceedings are Mr. Lucius Murorwa, partner at Murorwa Coutts Casper Incorporated, as well as Advocate Mati Asino, that is the former government attorney of Namibia. Leonard Friends, welcome to the Wheels of Justice.
Thank you so much.
Thank you so much.
Of course, I should thank you for agreeing to provide your pro bono services to members of our public. It's quite a patriotic thing to do.
Yeah.
Thanks.
Perhaps let's get this started. Mr. Murorwa, this is basically your first appearance on the Wheels of Justice, and it's customarily that we afford or accord those appearing for the first time an opportunity to basically raise any preliminary point or to basically state their maiden statement, if any, anything.
Yes, thank you, sir. I extend greetings to the Namibian people all across the land, and I'm happy to be part of this engagement with them on this important topic of the electoral process and the election that we are soon to participate in. And I basically wish Godspeed to all of us, and that I trust that the election would proceed seamlessly and that hopelessly, of course, it would produce winners and losers, but whatever the outcome that we as Namibians, emboldened by our past experience, would take the results as they are and move on.
That would basically then avoid disputes.
Yes, generally, I think we have conducted ourselves well, relatively. I mean, when one has regard to our past experiences, and disputes were conducted civilly, even though they may have been emotive, but by and large, they were handled through the judicial process efficiently, and we moved on. Hence, we are here looking forward to the next installment of the electoral process.
Thank you so much. I'm looking forward to this conversation tonight. Advocate Asino, of course, albeit you are not a first comer here, we should not deprive you an opportunity to raise any point in limine, if any.
Thank you. Greetings to the President and to the people of the Republic of Namibia. This is really a great opportunity for us to sharpen our processes of electoral process. Election is the most critical part of our lives. And I'm very happy to hear that the number of people who have registered to vote are a big number, and they should really go and vote and put their heart and mind and soul in what they do and elect the correct president or the president and members of parliament. in our upcoming elections.
Right. Thank you so much. Then first thing first, which, according to you, Leonard Friends, were the key electoral legal challenges in Namibia since the advent of our independence? Perhaps let's start with you, Mr. Murorwa.
Yeah, thank you. I think what stand up most, or what comes up most probably, would be the rally for democracy versus the Electoral Commission of Namibia 2009 challenge, or the challenge to the 2009 elections. There were many, but by and large, probably given the extent to which the emotions of the nation was captivated by that electoral challenge, I would probably pick that as having been the premier challenge that was brought. But by and large, there were others lately. Probably the latest one was the Chirare case that spoke to basically the post-election candidature to members of National Assembly. But within those constraints, I think the most important one was the Rally for Democracy and Progress challenge, which was dealt with by the Supreme Court.
Yes, but Mr. Murorwa, if in broad stroke we can just remind our viewers again what was the Rally for Democracy and Progress versus the Electoral Commission of Namibia about?
Yeah. I mean, typically, just like in any other election, that was a challenge aimed at the outcome of that election, which was challenged on the basis of perceived irregularities that were perceived by the applicants, and that full-blown litigation proceeded both in High Court up to the Supreme Court, and the Supreme Court basically found that there had been no electoral fraud or corruption pertaining to that election, and that to the extent that there were administrative misdirections or mishaps, they were not material. So the materiality question ultimately decided that election, and that the Supreme Court ruled that to the extent that there were administrative errors, those errors were not materials so as to affect the outcome of the result or the direction of the result, and correctly the result stood. And hence, here we are as a nation moving towards the next installment of the electoral process.
Advocate Asino, which challenge stood out for you?
Yes, well, the challenge of PDM in the process where the candidates who were elected on the list were removed and replaced with others. And the court went ahead and found that actually that is unlawful. It should not have happened. And the electors, when they went to elect the people on that list, should be honored as it is. Because the election, every vote has its importance. And when they are counted together, it's the most powerful force that anyone can have in the country. So to me, that is a landmark case where really the interference with the electoral process should not be entertained at all. Yeah.
I expected you to mention the EVM challenge by an independent candidate, that is Dr. Panduleni Itula in the 2019 election.
Yes.
Yes.
What do you make of that specific case?
Well,
I mean, it brought to an end the use of
EVMs,
EVM
yes,
without a verifiable paper trail.
I think it equally ranks right up there, but probably to the extent that the Panduleni Itula challenge was confined purely to the presidency, maybe that probably derogates from that challenge compared to the one of Rally of Progress that basically spoke to the members of National Assembly, from which ultimately the members of executive are chosen from. So I thought in terms of the scale and impact, the Rally for Democracy and Progress case was probably the most prominent in my view, without necessarily detracting or taking away from the EVM challenge. But I'm happy we are here and that a paper ballot-based elections would be held going forward. Yeah, but then on the question of this PDM Chirare case, you see, I'm not sure whether that has been the final word, because even though the Supreme Court confirmed the ruling, we probably ultimately will have to reconcile the constitutional supremacy, where in terms of Schedule 4 of the Constitution, it explicitly provides power and authority to political parties to select in their own discretion members of National Assembly. It's too tired in the sense that even though the Electoral Act provides for submission of candidature list on the basis of which the elections are held, the supreme law of the land, the Constitution, ultimately provides the parties the power within their discretion to submit their electoral list. I mean, I'm saying this because the Constitution is supreme, and that Parliament should not be seen to be legislating to take away from the letter and spirit of the Constitution. So when the Constitution in Schedule 4 says something, I thought the Electoral Act should actually yield to the superior law, which is the Constitution, meaning that there should be scope for political parties to choose, notwithstanding the candidature list that they had submitted to the ECN, that ultimately Constitution empowers them or provides them the necessary discretion to submit a list of their choice to Parliament.
I know Advocate Asino want to say something about your opinion, but
Yes.
is it your Leonard opinion that the PDM then case is not case closed as such?
Well, the Supreme Court has spoken. There has been a ruling, but like I said, it's an evolving matter that I'm sure.
Do you foresee it coming back to the court role?
Yes, I foresee that matter. In fact, this very matter or similar matter is being entertained by the MK party in South Africa.
Right.
And I'm sure, having considered Schedule 4 of the Constitution, that there is a debatable issue in a sense that once the Constitution says that political parties are entitled within their discretion to determine their list.
Right.
The Electoral Act should not be seen to be contradicting the Constitution. It must yield to that language of the Constitution. So I understand the Supreme Court has ruled in favor of the applicant Chirare and others, but I think it shouldn't be the final word. We should probably reconcile Schedule 4 vis-a-vis the Electoral Act. And
Advocate Asino.
Okay.
Yes.
Yes. It is a very interesting legal question. In fact, we ponder about it, and we took the position that indeed the political party have a right to field candidates that they deem fit to be in Parliament. However, the court was very specific in saying that you are only limited to say if the list is provided, that list should be honored or be observed as it is. After the elections, if you happen that you only have a list of, say, 20 people, but at the end of the day you end up with 25 people, then the party is free to add on the 5 people, but not to remove the people who are on the list. The procedure to remove, because once they are there, their rights vests, the rights arises and they vest, and so they have a right. Now, if that right is going to be removed, there must be a process. And normally, the process is to recall party member from parliament. And there is a process that must be followed. Yeah. So I understand. I think it's very keen to see what is the development of the jurisprudence in regard to this. But really, when you field a number of candidates on your party list that you submit to ECN, and at the time of the vote they are on the list, I think the electorate should not be duped or misled to believe they voted for these people, but then the other people who are coming.
Right. Do you believe or do you think any other court may come to a different conclusion? Of course, notwithstanding that the Supreme Court of Namibia confirmed the ruling of the High Court.
Yes, it's very interesting.
That's the highest court.
Yes.
I mean, that's the law.
That's the law.
All we are saying is that...
I'm asking that at the backdrop of Mr. Murorwa here saying perhaps this is not case closed. We might see a similar challenge back in our courts.
Yes.
I mean, will then our same courts come to a different conclusion? Of course, maybe borrowing from the development of the jurisprudence, as you said, maybe in the South African
Now,
case.
all I'm saying is that, you see, accepting the finality of the Supreme Court's pronouncement, one could not reasonably exclude the possibility of further challenges around that provision, which is basically inspired by Schedule 4 of the Constitution. So whether or not an electoral list is immutable, whether it's not capable of being changed, given the constitutional basis providing the political parties the right in their discretion to change the list of candidates. So I'm saying the debate is probably still ongoing, and we should probably obtain additional learnings from the MK party's challenge around that very question. And probably there would be additional legal pronouncements from, of course, its foreign jurisdiction. As far as Namibia is concerned, there has been a final ruling on that point for now. But I foresee that there could be further challenges reasonably based on Schedule 4 of the Constitution.
Thank you. Perhaps talking about these cases that we say have been quite significant, perhaps talk to us about how these cases shaped or contributed to the development of our jurisprudence.
Yes, indeed, the cases are very important because it helps us interpret what the law says, the Constitution as well as the Electoral Act. And where it's lacking, I'm sure those portions can be struck down and be declared unconstitutional. And then Parliament is given another avenue to rectify, if there is any. Yeah, or on the question of the Supreme Court interestingly has ruled, of late that the Supreme Court judgments are binding, and even on the Supreme Court itself.
Right.
Yes. So unless it found that it's a dicta, that was just not really part of the judgment, but that is a very important development which enforces that whether you are in the Supreme Court, whether you are in Parliament, whether you are the President, the ruling of the Supreme Court are final and binding. There is no... So it's a very interesting question. If you are going to come, maybe we'll come with another angle. I'm sure as legal egos, as you like to say, we'll find another way of attacking or coming to court with an issue related. Yes, but as far as it's concerned now, it seems really that that list must be honored and must be followed as it is. Yes.
By the way, talking about jurisprudence, Mr. Murora, what purpose does really jurisprudence play in so far as it being a source of law? Can we really say jurisprudence is quite a compelling source of law?
Yes, I mean, jurisprudence basically speaks to legal philosophy, which basically which basically speaks to, like any other philosophy, it asks fundamental questions about the law. And these questions crop up over many decades and centuries. I mean, people all across the world were seized with questions of, for instance, what is the law? What is the source of the law? What is justice? What is the relationship between justice and morality? And so forth. These are jurisprudential questions that basically speaks to the development of the law. But be that as it may, specifically as regards our electoral challenge, the learnings from the judgments of the court are instructive because it provides the interpretation that the court gives to the provisions of the Electoral Act, and that it informs any future litigant coming before court that he or she would have to take learnings from the judgments that the court has already given on that particular subject. But be that as it may, jurisprudence informs and it's contributory additional to the statutory law, which is codified in our case, Act 5 of 2004, which is the very, very comprehensive piece of legislation governing our electoral process, and supplemented correctly, as you have indicated, by jurisprudence emanating from various judgments of our High Court and Supreme Court. Yeah, including at local level, the Electoral Tribunal.
Yes.
I mean, they also contribute in pre-electoral challenges to settle disputes. I mean, basically, these are dispute settlement mechanisms, and if, as a society, and as we are evolving and we are becoming comfortable with matters of elections, increasingly we may find that disputes should probably lessen rather than increase. But, well, the jury is out. Let's wait and see. I think there is clarity, more or less, about the landscape of the legislation. I mean, there is reasonable certitude. The law is codified, and it's basically, for us as society, we are enjoined to follow and apply the law as is, apply the letter of the law, and hopefully that we will see avoidance of needless disputations.
Right.
But like I said, it's an emotive process. I mean, elections has got winners and losers, and oftentimes people who are aggrieved are raising these challenges.
Thank you. Thank you so much. Advocate, any addition to the significance of jurisprudence?
Yes, jurisprudence is very significant because it really sets the law. You have the Constitution, you have the acts of Parliament, and then you have the judgments. Judgments are going more into issues of interpretation and giving guidance on how, for all of us as a citizenry in the country, or whoever is conducting business in Namibia, to observe those laws in the way they are instructed by the jurisprudence. The jurisprudence is the law. It's a law. So we must have regard to it. All citizens are expected to know the law. So even then, ignorance of the law, as they say,
is not an excuse.
It's not an excuse. So it's valid, and it's, when matters of elections come afore, it requires that those who bring them, who are aggrieved, let them really take back, and then when they come, let them come with crystallized issues. The doors will not be closed for them, but let them come with crystallized issues so that when they come before the tribunal or the Electoral Act or the Supreme Court, they are clear, and then there will be a clear ruling and creation of further jurisprudence in interpreting, according to the facts that were before the court or the tribunal.
Perhaps, gentlemen, let's then talk about the different electoral platforms that exist in Namibia in broad stroke. What are they?
Okay, we have the Electoral Tribunal,
yes,
which is a court which normally gets established at that time when the dispute arises. And that court is either a retired magistrate or a magistrate is appointed to conduct the hearing there. And it really pertains to issues that arises before the election. In the issues of registration, such as, the names are not included on the list, or the names are not included in the register. Like the important exercise that we are doing now, that the register is lying open in all magistrate courts and everywhere. It's now where we go and make sure that our names are there. If not, then we must approach the commission. And if we are still aggrieved, then we can approach the tribunal. And it is given quick powers to resolve this dispute. Very quick resolution. Yeah, and so the other one, before I think I go to the electoral court, I would say is the commission itself. The commission is mandated to make certain decisions. And if any member of the public or the citizenry is aggrieved, then they have the right to appeal to the electoral court. And those who are not satisfied with the ruling of the tribunal are also given the right to appeal to the electoral court.
Just advocate there, just for clarity, when does the commission itself exercise this power? Is it after the tribunal or before the tribunal?
Issues related to leaving out names, that means the commission has already exercised its mind.
Right.
It has given a decision that no, you are not fit, or you don't qualify to be on the register of votes, for instance. Then that person who's aggrieved, then they have the right to approach the tribunal.
Right.
Yes. But there are other decisions like pertaining to parties that normally, once the decision is made, the appeal is to the electoral court. So, yeah, those are the two institutions at the first instance. The second one is the electoral court. Electoral court has really inherent jurisdiction to hear all matters pertaining to election, other than those specifically granted to the tribunal or to the commission at the first instance. So that's why I mentioned that it's important to note that the appeal for decision of the commission and the decision of tribunal is to electoral court.
Right.
Yes.
Thank you.
But then there's one more.
Right.
The Supreme Court pertains to president election, after the election, normally. And that's where if a person is aggrieved, like the one you mentioned of Pandureni Itula, went to the Supreme Court, it's a right court. And that's where he can, his grievances addressed. Yes.
Perhaps, gentlemen, I just want us to, on the same question while we are on the avenues of recourse, just to take it step by steps for members of the public. I would want perhaps, of course, like we said, this is pro bono, Mr. Murorwa advising a political party aggrieved, advocate advising just an electorate who perhaps feel that their name have appeared in some kind of political parties papers or independent candidates nomination papers when themselves feel that they assure that they've never consented, they've never given their signature nor their ID number or whatsoever. Let's start with the advice for a political party.
Yeah. I think generally the scope of grievances that present themselves are ones in nature of perhaps interpretation of the act. Alternatively, where an aggrieved party would want to bring an application to compel compliance with some or other provisions of the act, interpretation, compliance, and then generally non-compliance with the Electoral Act. The dispute or any grievance has to be grounded on the Electoral Act itself. I mean, you can't have an unrelated dispute brought before an electoral court. It has to be something related to the contravention of the Electoral Act or an interpretation of the provisions of the Act, or maybe you challenge some or another decision of the Commission. So there are those range of disputes that are capable of being adjudicated before an electoral court. So they must relate to the Electoral Act. Yeah. So my advice to political parties generally is that, well, they should play by the Act, and that there shouldn't be a general predisposition towards disputation. We, of course, without excluding it, our first preference would be that the elections would be conducted in the spirit of the law, and that there would be winners and losers, and we move on as a nation.
Right.
Yeah. So, in fact, a bigger question would be beyond the electoral politics. What is in it for the voters? That probably is a far more important question than purely grievances pertaining to winning and losing in elections.
Yes, but should they be aggrieved? What are the steps they should take?
Equally, the voters, should they be aggrieved as individual voters, they would then have to follow the dispute resolution mechanisms provided for in the Act itself. Like Advocate Asino explained, that when they are aggrieved, they have an electoral tribunal to go to that is in a pre-election phase where we are in right now, up to the point of elections, and beyond that, the electoral court being the High Court, and the Supreme Court, you appeal from the Electoral Court to the Supreme Court and direct challenge in relation to the presidency.
Thank you.
It's open to the Supreme Court.
Thank you so much. Advocate Asino will hear your advice, but let's first open up our telephone lines. You're watching The Wheels of Justice. On the agenda tonight are the avenues of recourse that exist for those aggrieved with any electoral process. When we return, we'll grant you the opportunity to seek counsel from our esteemed panel for any relevant intervention. Stay tuned. Welcome back, Namibia. Remember, you need not ever miss out on any of our episodes, even and especially if you are outside the borders of the Republic of Namibia. Download the NBC Plus application to enable you to remain part of every session in real time. Having said that, our telephone lines are now open for any questions or comments in as far as recusals or in as far as electoral disputes are concerned. Our telephone number is 061-291-3339. That is 061-291-3339. Your calls are now welcome. Right. Yes. Advocate, we want to hear what advice or yes. what are the steps yes. that an electorate should basically take to make sure that their grievances are addressed.
Okay, your question to me is related to a person who's on a party list?
Yes.
Which is not correct.
Yes.
I think that is a part where the party list normally is done in accordance with the party constitution.
In fact, I mean, it's a new political party. If it's a new political party that seeks registration, and the requirement is that this party collects a substantive number of names or supporters or signatures.
Yes.
And Nadunya finds his name basically in the list of those supporting that political party for registration, when Nadunya is clearly sure he never consented, he never gave, he never signed for such.
Okay, I think
Nadunya is now aggrieved.
If you are aggrieved now, it's against the party, not against the Electoral Commission.
Right.
So you must take up the fight with the party to make sure that they remove their name from that list.
Right.
Instead of going to the Electoral Commission. But then we must take cognizance of the fact that you as a citizen, you have rights. And you can exercise those rights by bringing your dispute before a competent court of law. Mm. Yes. So
basically you can go to the tribunal and say, look, my name appears in some documents of Party A or Party B, and I've never consented. I've never given.
I believe so. I think that is the correct avenue to follow. It's pre-election, and those are issues that should be dealt with by the tribunal.
Hmm. Litigation is a costly and at times very time-consuming exercise. What are other alternatives, perhaps, that exist to solve problems other than direct litigation?
Yes, I agree. I mean, litigation is genuinely costly, and our people, for reasons of our history, do not have financial resources to mount expensive legal challenges. So, I mean, the obvious route open to, for instance, in the example that we have given.
Mr. Mrora, I'm sorry, you will have to hold your thought right there. We have Mr. Dawson on the line. Good evening.
Good evening. I have three questions. The first one, it will be very quick. The first one is, what's the legality of the voter's card? The legality of the name of the voter writing in capital letters on the voter's card. The legality on that one. The other one is, I want to know if somebody's name appears on 3 different political parties. Is it a correct thing, or is it not legally correct? If it's not legally correct, I would like to know from the Constitution, it says that you have the freedom of association. So you can be a member of this party, but you can also be, if you wish to, a member of another party. So what prohibits you to do so? Because the Constitution makes it very clear that you have the right to association. That's the other one. The last one is, when it comes to voting, on the ballot paper, when in 2009 and 10, there was thousands and thousands of ballot papers, me, myself, as an investigator, in that case, find thousands and thousands ballot papers without voters' registration card numbers. But still the court say, the appeal court say that the evidence is not enough. How much
Dosen,
must
if you
your
can just-
evidence be
Mr.
to
Dosen?
be enough if there's such a rigging in an election?
Mr. Dosen,
Yes?
if you can just speak a little bit louder, because we are struggling to basically hear you.
Oh, okay. The first one is the legality of your name in capital letters on your voter's card, according to the Black Law Dictionary. What is the legality of the voter's name in capital letters on a voter's card? The second one was voters can appear on many different parties. People's names can appear on various if the people decided to be part of Party B and decide to be Party C or D, because the Constitution makes provision for freedom of association. No one is prohibited. So can they explain to us, because you find even that some parties make a case that their member's name is on another party's list, but the Constitution, is it not contradictory to the Constitution that says you have the freedom of association? That is one. The other one is when it comes to the ballot papers during elections. I was an investigating officer in the 2009-10 elections, and I find thousands of ballot papers without voters' registration card numbers on it. But still the appeal court say that the evidence was not enough. So how much must it be to be seen as enough and be seen as legal or illegal? I thank you.
Thank you, Mr. Dosen. Perhaps let's get to interrogate these questions. The legality of a voter's name written in capital letter on a voter's card.
Yes. On the first question of the voter's card name, the name that must be registered must be the name that is on your identity document. It must be precisely the same name.
Right, and it should be in capital letter.
Okay,
that seems to be the question, isn't it?
Whether it's in capital letter or not, so long as the identity can be ascertained, because it's to ascertain whether it's you whose name really appear on the voter's card.
So you cannot have a voter, you should rather not have a voter's card if you don't have an ID document, identity document.
There are processes that are available to allow even those who don't have identity documents, for instance, a person represented by a certain person, and they give the name, and that name is really of that person, then it should be, that would be the name that appear on the voter's card.
Right.
Yes.
Perhaps another question is, should one appear in 2 different or 3 different political parties? Perhaps it's a question of dual membership.
Yeah, I think it's an interesting question that the caller has raised, whether, say, in a process of registration of a political party, whether or not he could extend his name in support of, normally a political party should garner 500 votes per region to register, say, in an instance of a new political party. So if a promoter of that political party, say, for instance, request a citizen to support their registration. So as I understand the question of the caller to be whether that association delimits him from otherwise being a member of his party. I think it's an interesting question. Constitution is correct, you are free to associate, but then the logic of the electoral law is that, and even though you may have support or you may have sympathies for multiple parties, you can only vote for one. I mean, say at the ballot. So in that sense, the association probably is implied to be for one party. But theoretically, I cannot see any objection to, say, in a process of merely supporting a party for the purposes of registration, whether one would take offense at a voter supporting a party in the registration process and then having done that, his other party complaining that our member's name appears on the registration documents of a rival political party. I think it's probably an arguable point, because one, it's in relation to compliance for registration process. The other would be a membership issue for a political party. But I hear the caller, there is merit to the point that he is raising, that he is free to associate, and if he or she wants to support one for the purposes of registration and another party for the purposes of the electoral balloting, I do not see these things as being mutually exclusive. They can coexist and life goes on.
Yes, perhaps let's look at what has been happening of late. We witnessed a number of pre-election challenges fail on account of jurisdiction. Perhaps how are we to understand jurisdiction, specifically the source or what source of law such jurisdiction is derived from? Yes, advocate.
Yes, if we go to Electoral Act, you start from section 162 to 170 something, 72 or 74 there. Yeah, that's where the jurisdiction of the courts are set out. So the Electoral Tribunal is set out and its mandate. The tribunal must only act in those specific powers given in terms of those sections. Not beyond that. Now, when you come to the Electoral Act is a bit more broad. It excludes those ones from the tribunal, but it includes everything else. Except the Supreme Court, where it's mandated to deal with it, with the result, with the challenge to the outcome of the presidential elections. So the question of so any issue that arises, so it can be dealt with accordingly. That's
Right.
what the law says, and we must all observe the law in the way it is set out, and we must ensure that when we bring a case, we must have jurisdiction. It's not matters of the tribunal that you bring to electoral court.
Right.
Then you fail on jurisdiction.
Thank you. A layman's perspective is basically that electoral challenges are dismissed just basically on technicality. Perhaps, Mr. Murora, and make us understand the rationale behind some of these dismissals based on technicalities and so forth.
You see, I do not generally subscribe to the notion of dismissal of, or that perception that matters are dismissed on basis of technicalities, because most oftentimes applications are founded on the basis of specific transgressions of provisions of the Electoral Act. I mean, you have got to frame your complaint within the four corners of the Electoral Act, and then the courts, in their approach, generally accept that substance over form. So in a sense, the courts would, in most instances, determine a matter on merits being the substance rather than on technicalities. So some of the times there is misperception that matters are dismissed purely on the basis of technicalities. Of course, courts must sift disputes. There's got to be a matter of processing of various disputes, because you don't want the courts to be clogged up with meritless disputes. But that being said, or meritless challenges before it, but that being said, generally courts provide hearing on matters, on merits substantively. Now,
thank you so much. Thank you so much, gentlemen. We are racing against time, but I just wanted you to explain these two terms in simple terms. Let's start with Advocate Asino ab initio.
Okay. Yeah, when the court ruled that a certain position was unlawful ab initio, that means from the start.
It was unlawful from the beginning.
From the beginning, it
from
was
the
unlawful.
Onset.
Yes.
Thank you so much.
Yes.
Mr. Murorwa, de facto.
Yeah, de facto basically it's a Latin term that means in reality, in fact, and it stands in a contrasting relationship with de jure, that basically say de facto you could be, say, a parliamentarian. In reality. In actual fact. Regardless of whether or not that has got a legal backing. That's why I'm saying it stands in contrasting relationship with de jure. That says as a matter of law.
Gentlemen, unfortunately, time has caught up with us, but thank you so much for making time for the Wheels of Justice.
Thank you.
With that, we've come to the end of the Wheels of Justice. We'll be back again next Sunday. I'm Daniel Nadunya, and this session stands adjourned.